Good afternoon, everyone. We're going to start momentarily. We're just going to let others check in before getting on to the substantive material.
Good morning. Well, looks like a whole bunch of people are logging on right now, so we'll give it another 30 seconds.
Yeah.
All right, I think we are good to go.
Hi. Good afternoon, everybody. My name is Andrew Zwerling. I'm here with Marianne Monroy. Marianne and I are partners at Garfunkel Wild PC, and it is our privilege and pleasure to give today's webinar, Managing Social Media Use and Matters of Political Opinions in the Workplace. Going over the registration list, we see a lot of familiar names of people who we know and we've worked with, but there's a lot of new names as well. And so for the benefit of those individuals, I'm just going to give a very brief overview of Garfunkel Wild and the background of me and Marianne. Garfunkel Wild, we're a full-service healthcare law firm with about 90 attorneys in New York, New Jersey, Connecticut, Florida, and Washington, D.C. And next month will mark 45 years since the firm came into existence. By full service, I mean healthcare, litigation, managed care, corporate, compliance, finance, mental health law, biotech, IP, and pertinent to today's presentation, employment law. With regard to Marianne and myself, we have decades of experience as litigation and employment attorneys, handling matters from the local trial level to the United States Supreme Court. And Marianne and I wear two hats, as many of you have heard in these presentations before. We're litigation attorneys. We know our way around a courtroom or an arbitration proceeding, but we also do day-to-day counseling, employment counseling, putting out fires on a regular, if not daily basis. And when we try a case or litigate a case, we get to see firsthand how things played out well or poorly for our clients, and we use that information to inform our day-to-day counseling. So it's a nice fit, and it works very well for our clients. We've given many presentations of this type over time, in person, as crowds as large as a couple of hundred, webinars with hundreds more. One thing, if you know Marianne and if you know me, we don't like giving speeches, and we know that the webinar format is less conducive to asking questions in an in-person dynamic. But you have a chat feature. We encourage you to use it. While we'll take questions at the end or even after, we encourage you in real time to ask questions as we go along so we can get your questions answered to the extent we can as expeditiously as possible. As for today's webinar, it's the first of a 6-part employment law series that our firm is presenting. The other topics that we will be covering are how to become a better supervisor to promote employee engagement and reduce risk, navigating employee terminations, practical strategies and best practices for employers, best practices for conducting effective performance evaluations, conducting effective workplace investigations, and finally, remote employment, best practices and key legal considerations. As for today's subject matter, especially in the time frame following the onset of the Israel-Hamas conflict, private employers, at least in our experience and those of our partners and colleagues, have found themselves confronted with knowledge of an employee's social media posts that may be or are contrary to the mission or business interests of the employer, making unauthorized representations on behalf of the employer and or just causing employees in the workplace to feel uncomfortable. We were last hit with a surge of these types of matters, these types of incidents involving this type of subject matter during the COVID pandemic, with employees, I should say, posting on social media, private social media sites, anti-Asian sentiments. As part of our series today, and in terms of the subject matter today, we're going to be discussing with you the legal and practical considerations of determining when a private employer may discipline an employee for his or her social media activities and what appropriate disciplinary actions an employer such as yourself can consider. So why should this topic be of concern and significance to you as an employer, as a private employer? A bunch of reasons. And again, we've seen it in the last year and a half, time and time again. Employees who misuse social media can have a devastating impact in various ways, legally, from a PR standpoint. For example, social media employee banter relating to protected traits such as race or gender may violate your anti-harassment policy or anti-discrimination policy and create a hostile work environment, just as it does if those sentiments were communicated in person. Employees griping or complaining on social media about their work environment may impact your reputation as a business entity. Social media may be used by employees, whether intentionally or not, and we've seen it happen in both ways, to divulge trade secrets or copyright protected or other confidential company information, or it may just be used, social media, by employees in a manner that may constitute hate speech or run contrary to a business interest of you in some impactful way. What are the risks associated with that? Loss of clients, loss of patients, loss of customers, loss of revenue, harm to reputation, loss of productivity if the accessing of the private social media sites are being done during work hours. It can result in inappropriate conduct between employees. It may have employees on their own time communicating on their private social media sites, and they may cross a line into harassing behavior, threatening behavior, discriminating behavior, or some wrongful or unlawful conduct that can expose you as the employer to liability. Again, it might be the disclosure of confidential information that may result in a breach of an agreement you have with a third party, or it may violate a confidentiality agreement that you have with a third party. Other ways that the use or misuse, I should say, of private social media can hurt you is if you overreact as an employer. You see something that you think is wrong going on, you act prematurely without being informed of the facts, and you act in a way that unintentionally exposes you as the employer to liability for how you responded to what you perceived, or I should say misperceived, as a wrongful use of private social media. So in light of all of these issues, it's very important for you to understand the legal landscape that you're working on in dealing with this particular subject matter.
All right, good afternoon, everybody. I will start off by just answering a question that was posed as to whether or not the session, there'll be a link to the recorded version of the presentation or access to the slides, and there will be. We usually put it up on LinkedIn within a couple of days, if not by the end of today. So you'll be able to access that information as well. All right, so the first thing we're going to talk about is what is social media? And most of us nowadays know what it is. Any digital technology that enables people to use, create, share content, opinions, insight, right? Whether it's over the internet or through mobile devices, laptops, notebooks, whatever type of device you may have. There's a variety of different platforms out there. Some of the most popular ones we listed below: Facebook, X, LinkedIn, YouTube, Instagram, TikTok. For now, I can't keep up with whether or not we have access to TikTok or not. Maybe Snap, that's what my kids tend to prefer. And these are the platforms, particularly Facebook, where we see employers getting notice of some type of objectionable post. And it's usually Facebook, for whatever reason, that I see that, maybe because Snap disappears. So, when we give leadership training programs focused towards the managers, we're always trying to focus on, look, we're not the Facebook police. Nobody is here. Employers aren't here to police all these social media sites. In fact, there are certain restrictions that don't let you, without authorization, access personal social media accounts. But when employers or employees or the managers use this material in an inappropriate way, it can have very, very drastic consequences on their position. In fact, I've seen careers tanked over inappropriate social media posts. Even if they're not unlawful, they could still have some dire consequences if they don't jive with the mission of the organization or perceived as discriminatory. So I caution employees at every level that social media posts, you really have to be mindful of what you're putting on there. For example, if a manager posts negative or unflattering information about a subordinate team member, and it leaks back to that team member, right? It shows poor judgment. It undermines the effectiveness of that manager, because what employee is going to trust that manager if they're always afraid that they might put some unflattering information on social media? And depending on the content, it could also give rise to a harassment claim. All right, so let's go over some of the general rules here. We're usually called, or whether it's our office or HR or management, are confronted with a post. It's generated a complaint, and you have to do an assessment. And in discussing the, you have to discuss the ability of the employer to restrict the social media use and discipline an employee for such social media posts. So where do you start in making such an assessment, right? So I always say start with what type of employee relationship do you have? Is it contractual or at will? Because if it's contractual, there might be some provisions that might govern some of the activity. And if it's at will, that's also important to understand, okay? An at will employment relationship just means that there's no contract for a specific duration of time, and either party can terminate the other for any reason, with or without cause, with or without notice, okay, except for unlawful reasons. So an at-will employee who's terminated for some type of protected activity, and we're going to go over some of the social media posts that might be deemed protected, like a political campaigning activity, you couldn't terminate the employee even if they were at will on account of those protected social media posts. And they're very limited because there isn't, as we're going to talk about in a minute, a private First Amendment free speech, First Amendment protection for employees. Okay. Now, just going back to contracted employees, there's often language in the contracts that give a right to discharge an employee who violates rules of conduct. So, for example, if the employee, let's say the company is a diaper company, and the manager posts in favor of cloth diapers and rebukes the use of disposable diapers that increase waste from their standpoint or whatever, right? That's going to violate the business interests of the organization, and more likely than not, your contract is going to say a person can be terminated for cause, right, if they engage in conduct that is deemed injurious to the business interests of the organization. So the contract might also help you in addressing inappropriate social media posts. Okay, second, we're going to analyze this First Amendment protection. For private employers, and that's what we're talking about really in this webinar, there is no First Amendment protection. All right, it only applies to government employees. And there are some state law caveats, and Andy and I are going to go over some of those. But there are states that place no constraints on employers and how they want to discipline employees for objectionable social media sites, one of which is Jersey, and Andrew's going to talk about it, that in a minute. So it is important to understand what codified law is out there and where social media fits in that, because there will be some restrictions. So with that, I'm going to turn over.
It's important to say that we're not going to go into the specifics by jurisdiction in any detail. But really the point of this webinar is to make you aware of what some of the issues are, what some of the risks are, in dealing with social media use by employees and so on. But we're going to touch upon some of these jurisdictions as illustrative examples of how varying the landscape is, regardless of where you may be, and therefore the need to go granular if you're in Jersey or Idaho, whatever the state may be, right? So New Jersey and Florida, these states do not have specific laws protecting employees from discipline for any perceived misuse of private social media. which leads to the conclusion that in those particular jurisdictions or others like New Jersey and Florida, where you don't have some specific law governing this particular subject matter, that the employer is going to have greater latitude given the absence of any restraints. So I can't stress enough, and Mary Ann and I are going to go into certain pitfalls that even if there is no codified law that creates certain guardrails, there may be other considerations that you need to take into account on how you act. Now, by way of contrast, you have Connecticut, and up on the screen, you have the Connecticut statute that deals, with the subject matter that we're discussing today. It's going to stay up on the screen so you can read it as I talk. But basically, under Connecticut law, an employer is liable for compensatory and punitive damages, as well as attorney's fees and costs to an employee who was disciplined or discharged. And then I'm just going to cut to some of the salient points here, on account of the exercise by such employee of rights guaranteed by essentially the U.S. Constitution or the Connecticut Constitution. To recover damages, the statute also requires the employee to show that the protected speech, again, you first have to show it's protected speech, does not substantially or materially interfere with the employee's bona fide job performance or the working relationship between the employee and the employer. So what does that mean? Well, Connecticut courts have made it clear that Section 31-51Q does not protect all types of speech, and that it shouldn't be construed as transforming every dispute about working conditions into a constitutional question. Again, in plain English, what does it mean? First, the employee is going to have to show that the speech at issue is constitutionally protected. And under Connecticut law, to be protected by the First Amendment, the speech must address a matter of what's called public concern, and the employee's interest in expressing themselves on this matter must not be outweighed by any injury caused by the speech. So what are statements of public concern? Those include statements that can be fairly considered as relating to any matter of political, social, or other concern to the community. And it's up to a court to assess whether or not a statement falls into that category of public concern. And the court's going to look at the content, the form, the context of a given statement in making that assessment. But again, importantly, the Connecticut courts have held that this particular statute also requires, again, that the employee's right to speak is not outweighed by the employer's interest in the effective operation in the workplace. So the impact on the employer is a critical component of the legal analysis as to whether or not the statute applies. And what will a court look at in Connecticut, for example, and it might be true in other jurisdictions that have similar language, they're going to use a balancing test of sorts in which they're going to look at the extent of the disruption caused by the speech, for example, on workplace discipline, harmony among coworkers, working relationship, the effect on the employee's job performance, the responsibilities of the employee within the agency of the company, and whether or not the speech is made publicly or privately, right? So again, in Connecticut, the impact on the employer is going to be a critical consideration. As Mary Ann's going to discuss next, New York, you're going to see parallels this.
All right. So yes, New York, when assessing the rights of employers to act on social media posts, we turn to a portion of the labor law. And at the time this section of the labor law was drafted, it was not really with social media in mind. It was meant to protect employees from losing their jobs for engaging in certain political activities or recreational activities like smoking that maybe didn't align with their employer's point of view. Now social media is being used or viewed in the context of this labor law to determine, okay, are there some protections? Are the posts protected under this particular New York law? So I'm not going to read the whole thing. I'm going to paraphrase, but basically under the labor law 201D2, it's unlawful for any employer to discharge an employee or take disciplinary action or affect the terms and conditions of their employment because of one of two things, right? They're engaged in political activities, which are defined very specifically, And we'll go over that in a little bit more detail. But those political activities are outside of working hours, off premises, off employers' premises, and without the use of the employer's equipment, assuming they're legal activities. And there were a couple of exceptions there that wouldn't apply to like media or news personnel or maybe some of the state executive offices. So the first thing we're going to look at when you look at, actually, let me step back for a second. So the law first talks about the political activities, and the other thing that's protected is legal recreational activities. So if you asked me a couple of years ago, marijuana wouldn't have been considered a legal recreational activity. Now it is protected. So, you know, if somebody is posting about where to get marijuana for recreational purposes, that would be protected now. So now what we're going to do is really try to assess, okay, you get in a post, somebody complains about something or other, and you have to start looking at this. Is it going to violate the labor law if I take action with regard to it? So the comments, were they done during work without the use of the employer's equipment or on premises? You know, so if people are engaging in social media and on their Facebook while at work on company time, right, then that's not going to be protected. There is a caveat there with the National Labor Relations Act. So if employees are using social media even during work hours in connection with union organization or communicating regarding unfair labor practices, that would still be protected under the labor law. The next thing you have to look at is also whether or not it's actually political activity, which is narrowly defined, or recreational activity. So political activities are extremely limited in scope under New York law. So while Connecticut's a little bit broader, matters of public concern, this is, it says, are you engaging in an activity about running for public office, campaigning for a candidate for public office, or participating in fundraising for the benefit of a political candidate or party? Those are what are defined under that law as political activity. So something that says, I support, let's say a post, I support Ukraine, I support Gaza, I support Israel, right? That's not going to be a political activity in New York and or protected, because it's not one of those three things listed in the site. It's opinion. Or I'm going to be fundraising to get resources to provide immigration legal services for a particular community, right? But that's not fundraising for a political candidate. So that's not going to be protected under this particular law. So you have to really analyze what is and what is not protected. And there's been some case law out there. There was a case some years ago where an employee was a Chinese political activist, and the courts found, like, after he was terminated based upon his political activities, said, well, he wasn't protected. And his political activities, he was involved with protests and movements and speeches calling for democracy in China and criticizing the Chinese government, right? And he was terminated in connection with those activities. And the court said, no, this is not a matter of a protected political activity. Now, there's interpretations of case law. Most of them will say, if it's very specific, right, there's strict statutory construction that, right, if the legislature wrote a law that set forth a definition that included three things: running for office, campaigning for a candidate, fundraising, right, then that's the be all end all. There is some limited case law out there that says, well, that really from a statutory construction standpoint, we're really looking at guidelines here. We expect that there's going to be more litigation about this, but everything is going to be somewhat fact specific. Again, the National Labor Relations Act, you know, the legislation that impacts working conditions, things of that nature, all going to be protected. The other thing we have done and seen where even since the recent election, there's a lot more discussion in the workplace between people that might prefer one candidate, or not candidate, between the current president and maybe the former candidate. And some of our clients have had a lot of disruptive communications within the office where people are not respecting the opinions of each other. And so sometimes it does call, an employer may, and we've helped draft memos to help people say, look, everybody can have and should respect the opinions of each of your coworkers, and you don't want to impress upon your particular opinions on someone else who's not welcoming that advice or welcoming that opinion, right? And it all depends on the situation. There may be places where a dialogue about current events is consistent with work culture. Maybe it's a nonprofit immigration type of organization, and the staff have united views. And so having a dialogue on that subject might be welcomed within the workplace. But more often than not, we see a lot of discord when people are engaging, whether it's social media or just verbally, about matters of political opinion. And again, you don't want to tamp down people's personal rights to discuss things off premises, after hours, but sometimes just having a conversation or communicating with employees about respecting each other's opinions is very helpful. All right. So now recreational activities, again, when this portion of the law was created, and also when I used it years ago, I've been practicing now nearly 30 years, it was mostly about smoking. So, smoking was commonplace in office buildings, restaurants, and everything. And so sometimes employers didn't want to hire a smoker. And so this law, I had to revamp policies where you couldn't just not hire someone because they were a recreational smoker. So it's like anybody who engaged in some type of recreational activity that was legal, let's assume it's legal, right, was protected. And so now that's kind of morphed into, using this for social media purposes. So are they involved with something that can be deemed, are they doing something that's recreational? And that would have some protections. And the courts have distinguished between what is considered a social activity and a recreational activity. So, and there was one case, I think the court had determined that extramarital affairs was not a recreational activity, it was a social activity, so it wasn't protected if some of that stuff was going on. And the same thing with, I think I said before, with legal use of marijuana, recreational marijuana. So I'm going to now turn it over to Andrew.
Okay, so as you can see, as Mary Ann described, there's pretty small windows of protected speech in the New York law. It has to be a political activity, a recreational activity, and the courts have really narrowly defined those terms. But let's assume an employee engages in what otherwise be considered protected political activity or recreational activities. Does that end the inquiry? And the answer is no, based upon the safe harbor provision in the labor law. The provision of Subdivision 2 of the section that Mary Ann went over shall not be deemed to protect activity which creates a material conflict of interest related to the employer's trade secrets, proprietary information, or other proprietary or business interest. So it's not enough for an employee to say, hey, I fall into one of those two categories in terms of what I said on Facebook or wherever. It's either political or recreational activity. This is a second line of inquiry that can enable an employer to step in and say, no, you can't do that, or you can't say that anyway. This language has I'm certain no one's memorized the slides that we put on and for just a few seconds, but this language is very similar to the Connecticut statute that we just reviewed. And basically this means that an employer can discipline an employee for social media comments where those posts are detrimental to the employer or impact the employee's job performance. So what does the term material conflict of interest mean in actual terms? Quite frankly, it's a bit unclear. There's not a whole lot of a legal authority that speaks as to this issue. So that gives rise to the question, does it mean that an employer has broad latitude in deciding what comments may create a material conflict of interest? Or does it mean something narrower? For example, that to show a material conflict of interest, you as the employer must be able to point to some, tangible and provable impact. The limited case law authority that we have found exists points to the former conclusion, that you don't have to prove some tangible and provable impact. There is one relevant case whose underlying facts can only be found through secondary sources. We had to do a little bit of digging. The basic facts are this: the employee worked for the German National Tourist Office and was terminated for Holocaust denial associations, and on the ground that the Holocaust denial conflicted with the business interest of the German National Tourist Office, which interest involved promoting tourism to Germany and German culture. That termination decision was upheld by the courts, including the appellate division. Now, there's no indication, to the point that we're trying to make here, that the court required some tangible proof of an impact to the operations or reputation of the German National Tourist Office before finding the termination proper. There is also a non-labor law 201 case in a very different context, but still relevant to what we're talking about here. One dealing with public employees and conduct, not social media posts. In fact, this goes back a ways, this particular case, that further supports the conclusion that an employer doesn't have to prove there was some tangible impact. In that case, it's the Licurdo v. Giuliani case. A police officer and two firefighters were terminated based upon their participation in a Labor Day parade and creation of a float that was highly racially discriminatory. The float that they entered in this 1998 parade was called Black to the Future, Broad Channel 2098. The float was a play on the 1985 time travel film, many of those who saw it, Back to the Future, which attempted to depict what Broad Channel would look like in 2098. It was highly inflammatory, racially offensive under any objective standard, but when they were terminated for engaging in this wrongful conduct, they actually challenged it. They sued the firefighter and the firefighters and the police officer, claiming they were terminated for the position in violation of their First Amendment rights. And the lower court, after a bench trial, actually reinstated them. But the Second Circuit Court of Appeals reversed that particular case, stating in part, and this goes to the point that we're making here, where a government employee's job quintessentially involves public contact, the government may take into account the public's perception of that employee's expressive acts in determining whether those acts are disruptive to the government's operations. And here's some critical language. Furthermore, the disruption need not be actual. A public employer may legitimately respond to a reasonable prediction of disruption. And that quote helpfully informs our analysis today of whether private employers must prove some tangible harm based on social media posts in order to discipline an employee. So again, some authority that stands, for the proposition that you don't have to prove, hey, I have less patients coming, I have less customers coming, or employees are quitting because of this. If it happens, it certainly makes for a stronger case on behalf of the employer, but you don't have to wait for the axe to fall before you do act.
I'll just flip to the next slide. Hold on. All right, and in piggybacking off of what Andrew just said, there are variables that you need to consider. So, and let's face it, most of the time, the offensive posts or the objectionable posts are not actually happening at work. And often the employees are trying to keep this stuff private. A lot of them know that it's inappropriate, but things leak out, right? So you might be friends and have 200 Facebook friends. Somebody's going to see something objectionable, and that's how things start to leak out. And it usually will get to HR or management, and you have to, take action, because now somebody's come to you and said, I find this super offensive. Maybe they're going to say, I feel threatened by it. And we have had that happen quite a bit. Or I feel unsafe, right? And you have to say, okay, well, let's look into this. We're going to make sure the work environment is safe. And you need to investigate. Now, sometimes you have the actual posting. You can make some preliminary assessments. Sometimes an employee will report a complaint, but don't actually have it. And as Andy will tell you later, you can't force the alleged poster to open up their personal Facebook account and show it to you. That doesn't mean you can't question somebody about it and say, look, it came to our attention, you did X, Y, and Z. So you could still do a form of an investigation. But 9 times out of 10, somebody's printed out, screenshotted the objectionable post, and it gives you an opportunity to look into it and make appropriate inquiry. And so on the screen, you'll see a couple of things that we usually take a look for in making a determination on how to address the scenario, whether it's discharge, suspension, counseling, training. So number one, does it constitute a threat? And I'm going to do these a little bit out of order here. So I always first right away say, is it a threat? Is it a call to violence, right? So if someone's calling for the genocide against a particular group or supporting violence, that is going to be right away a red flag that we need to address that, not just a red flag. It needs to be addressed and swiftly, and often that's going to be a termination, right? Posts about opinion, right? What they feel about Israel or the war or Hamas or Gaza or whatever it might be, that isn't necessarily hate speech. If it's just opinion, pure opinion, not a call to violence, okay? It doesn't mean that it might be against certain interests that your company might have, and it still requires some action, but these are the different variables we're going to look at. The hate speech I look at, so putting aside threats of violence, is it hate speech? Is it someone saying, I hate all, fill in the blank, whatever kind of category? Is it racist, anti-Semitic, a white supremacist? Those types of things where it's demonstrating a clear hate for a particular protected category. Do the comments negatively impact the employer's reputation, relationship with clients or customers or the community at large where they serve, okay? So for instance, an employee works at the NAACP, but they're posting about white supremacist groups, right? That's not going to jive with the employer's interests. And for a variety of different reasons, it's probably even going to fall into the hate speech. You're going to check off a number of boxes there. All right. Very important one. Do the comments actually give rise to criminal culpability, right? So if the social media post is suggesting that someone's going to engage in a mass shooting, or maybe they're aware of somebody who's going to do it, or say somebody in your office is going to do something like that, or hurt somebody, it doesn't even have to be a mass shooting, right? That's something that you're going to have to consider and take action. Are the posts indicative of child abuse, child exploitation, child pornography, right? There are times where the posts that come into question, right, may be unrelated to the workplace, but there's an obligation, a moral, ethical obligation to report this to the police if you get wind of something like that, okay? And I'm sure everybody would feel the same way about reporting those types of things to the authorities. And there's a duty, right, for protecting the work site. So if you think a social media post suggests that there's an unsafe condition at the work site because someone's going to lose it at the work site, right, you have a duty to address that. Now, do the comments result in a hostile work environment or otherwise have a negative impact on the workplace, right? So then I'm looking at, well, is the post derogatory toward other employees? So for instance, let's say if someone, like maybe it's a manager that says some comment, well, all the back office staff is comprised of X group, maybe they'll say females, right? So you have to expect they'll be incompetent or easily confused, right? Very derogatory, could be indicative, is really indicative of a gender discrimination type of claim, a hostile work environment. So that's something that you're going to have to address. And that flows right into, does it violate your employer's written policies? So if you have anti-harassment laws and you have someone posting negative comments about females being incompetent, right? That's not only going to be a discriminatory comment, it's going to violate your written policies, and you should have those policies. Maybe the person's purporting to speak on the behalf of the company, and that's against your policy. You don't want employees making representations on behalf of the company. So let's say the employee posts, my company supports anti-vax legislation, okay? or some kind of post that's designed to retaliate by embarrassing an employee who reported a complaint against them, right? Those would be violations of policy. The person who is retaliating or speaking on behalf of the company without authority to do so. Next, you really have to assess, okay, how do you handle the situation once you've made this assessment? And there's going to be, a scope of different, how bad is the post or how does it affect you? Sometimes you might look at it and say, well, look, this is just an opinion. It's causing no harm that we could say, and maybe if there isn't really much that you can do with that. And I'll talk about in a minute, there might be a memo that goes out about respecting each other's opinions, but there are things like discharge, counseling, warnings. Often we're able to encourage the poster to take down the post because it's offensive, even though it wasn't maybe meant to be offensive. We're usually able to have a conversation with the employee and say, you might not realize it, but what you post was really offensive to somebody. And can you remove the post? And it's often they do that. Now, as far as memos, especially after the election recently, as I mentioned before, there was a lot of contention in the offices. People felt very strongly about the candidate that they supported. So here's an example, and I'm going to paraphrase a little bit, where an employer sent around like, look, I'm going to paraphrase, with the election of the new president and ongoing global conflicts, we remind employees of the importance of respecting political views and opinions of their coworkers and colleagues. Each employee's perspective is valuable, and we understand that discussions on politics and global concerns can be sensitive. It's crucial that we all refrain from imposing our personal opinions on others during working hours to ensure everyone feels safe, always feels valued and heard. But we also put down in there, it's important to remember that this reminder is not about restricting your rights to engage in political activities outside of working hours. It's really about fostering positive and respectful working environment, and so that everybody feels comfortable. And sometimes something like that reminds people, like, look, if you're chit-chatting with somebody in the open, and maybe the two people are perfectly fine in this political debate, but there are three people that are sitting next door that have to listen to it, right? They might not feel comfortable. And again, it's something that you have to look at and on a case-by-case basis.
And essentially just to create a structure, like if you're thinking, okay, Mary Ann and I have given you a lot to think about, and we're going to give you some more to think about. You don't necessarily have to focus on what's the definition of political activity, what's the definition of recreational activity. If you're not sure, what direction to turn as far as restricting certain statements on social media, look to that safe harbor. Is it undermining an interest or creating undermining some material interest of you as the employer? As Mary Ann went, into detail about, does it violate any of your policies and so on? Use those as your starting point for how you're going to respond, taking into account the culture in your particular workplace. Some places are more liberal or not with regard to what kind of speech, whether it's in the workplace or on private social media sites, takes place. There's not a one size fits all kind of mentality. So what are some of the best practices? Have a social media policy. We can't stress enough that if you have a properly drafted and enforced policy, it's not enough to have it on paper. That's true of any policies, as the two of us have experienced. Hey, I have a handbook. Yeah, but you never enforce it. Same thing with your social media policy. Have one, enforce it. It's going to create the roadmap for employees to set the expectation bar, what I can or can't do as an employee. If you set forth the expectations really plainly, and again, tailor it to your particular workplace. Different entities, you're going to have different content with regard to their social media policies. And again, it's going to give some guidance, some instruction to your employees on what is going to be tolerated or not, what you'll be accepted, or what may subject them to some form of, discipline and whatnot. So what are some of the things that you want to talk about in that policy, as far as laying it out for employees? let them know that there's no duty of privacy that can be expected with the use of employer systems, what your level of tolerance is as an employer. Decide whether or not, and again, each workplace will differ, whether or not you're going to permit or even require the use of social media for marketing or business development, for example. You want to consider how you're going to respond as an employer if the employees do post something that's inappropriate, maybe not unlawful, but as Marion was pointing out, it may not be against the law, but it still may be violative of some of the standards of your workplace. All right. Consider how you're going to respond, taking into account what you're allowed to do as an employer, what you can't do as an employer, how you're going to monitor compliance, and use that policy to remind employees. And this is what Marianne was stressing before too. You can have all these rules, you have all these legal constraints, but you want to remind your employees that the public or the workplace social media activity is not private. And that the employee has a right to correct, if you're talking about workplace social media activity, unproductive or harmful employee social media use is necessary. But secondly, with regard to private social media, being respectful of others, and how if you cross that line, it can blend or bleed into the workplace and have consequences to the employee who's misusing private social media.
All right, so just going to try to switch the slides here. Bear with me for a second. Okay, so I'm just going to talk briefly about the last bullet point on the bottom, and it's about providing training for the use of appropriate use of social media, right? So you can have the social media policy, but if the managers don't know it exists and they don't understand it, or they don't enforce it, you're going to have a problem. The other thing I usually just like to point out, there's permissible types of electronic monitoring and surveillance. So most organizations will have policies that say there's no right to privacy when you're dealing with emails and anything that's put on network information, right? So if an employer has reason in connection with an investigation to look at business email accounts, they can do it. There are some caveats, right? So if you start looking at the emails and maybe the particular employee has their personal Gmail account set up, I usually I'm cautious about going into the personal Gmail accounts unless there's a legitimate reason. And even with that, assuming your social media policy or your electronic media policy says you can do it, if by chance you open it and you immediately say, oh, this is a communication between an attorney or other privilege protected communication, health information, the employer needs to immediately close that particular email or electronic communication. The other thing too is you can't make up a fake persona so that somebody friends you, right, to get their social media information. Or yet say to a coworker or another team member, you know what, why don't you friend so-and-so? They'll friend you. You can get access to this information and then you share it with me. That's not appropriate, inappropriate, and can be considered unlawful in certain things. So you have to be mindful of that. Another thing I always want to point out, and this is also part of the training so managers know, this background checking through the internet and social media sites can run you into a lot of trouble. So number one, for certain type of background checks, like a criminal background check, you need consent. So you shouldn't be popping on to websites, checking court dockets and things like that, or criminal case histories without consent of a candidate. But there's also things where you can learn, maybe they're part of a particular organization, maybe they're posting about their participation in AA or a mental health support group, right? You now have this information. And maybe you don't hire the candidate because of legitimate business reasons, but if they get wind that you're searching their accounts, their personal social media accounts, and looking at their participation in certain organizations, and you don't hire them, it gives rise to a potential discrimination claim. So usually when I have clients that say, well, we just check the internet, well, limit it. Have a policy that says we are only going to look at LinkedIn and what people put on in LinkedIn, because that's pretty business oriented and usually you can stay out of trouble. You shouldn't be trying to access personal Facebook accounts. And as I said before, there's employee privacy rights. So again, if you come across what appears to be in a protected medical or legal communication with counsel, you would refrain from opening those. I think we're on the last slide.
Well, and just to segue off of what Mary Ann was talking about with regard to wrongfully accessing the employee's private social media site, in March of 2024, a little more than a year ago, New York enacted a statute that bars employers from accessing an employee's social media account login information, such as usernames and passwords, as a condition of employment. Because there were instances where an employee would say, hey, Bill Smith posted on his Facebook account some offensive thing, and the employer would call Bill Smith in and say, okay, Bill, I want you to go to your Facebook account, open it up. I want to see if this is true, right? Thinking, oh, well, I'm doing an investigation. I want to find out the facts first. Well, under this New York law, you can't do it. The employer is barred from compelling the employee to disclose any username and passwords or any other form of authentication for accessing a personal account. You can't compel the employee to access the personal account in your presence, like in that scenario I just walked you through, or to reproduce in any manner, photographs, video, anything from their private social media account is off limits. And you can't discipline the employee for refusing to allow you access to their private account, okay? The legislature just found that there are instances of wrongful behavior that stem from allowing employees to do it. So that door is now shut. All right. So just keep that in mind if you're involved in an investigation into alleged wrongful use of private social media.
Right, and I'm just going to touch briefly about social media posts that may be deemed, if you interfere with them or discharge or discipline someone on the basis of activities, social media posts that are considered concerted activity, right? So concerted activity is protected under the Labor Relations Act, sections 7 and 8. And basically that's the right to organize, unionize, or communicate or oppose unfair labor practices. Okay? And it's unlawful to interfere with the right to organize or oppose unfair labor practices. So if you're trying to discipline somebody who's engaging in concerted activity, there will be a problem. And there's differences as to what is and is not concerted activity. If it's just a single employee who just has a personal gripe, hates their boss, demeans their boss, and it's not really about any unfair labor practice, that's not going to be protected. So you could just, one employee could be griping on behalf of himself or herself. That's not going to be it. Versus two or more people getting together to advocate for better working conditions. So a post that says the housekeeping team is being required to work through lunch, right? And they're entitled to lunch, or not getting all their overtime pay. And they're speaking on behalf of a group of employees, or purportedly speaking on behalf of a group of employees in that social media post, that would be protected. And so the other thing I would mention just with concerted activity and where this came up a lot some years back, people used to have, or employees used to have, these anti-negativity policies. And the National Labor Relations Act, or the board, said, oh no, because that prevents people from talking about unfair labor practices. So this is really stemming from years ago, using this particular section of the act to say you can't have just blanket no negativity. And there was a case back in 2021, Trader Joe's, during COVID, an employee was complaining about customers lingering about in the store while shopping. Presumably he felt it was like, they should get their stuff and leave. We're in the middle of the pandemic. But the court agreed, like, look, this is not protected, right? And Trader Joe felt it violated their policies about treating customers with integrity, and that this in particular employee was speaking on, it appeared that he was speaking on behalf of Trader Joe's, that people should just get their stuff and leave. And the court said, nope, seems like it's a disloyal employee who is disparaging either the service or a product or the customers, and not really in furtherance of a labor dispute. So really, you have to look at it and don't automatically say, oh, this is not something I want around about my company that's being posted. But take a few moments to assess it. Is it something that's protected, that's being talked about? And then you may have to take a different course of action.
And then lastly, avoid a hasty and premature judgment of the facts. Don't rush to judgment. Don't react hastily to information. Avoid the potential for overreacting. When one hears that something has been posted on the internet, there's that knee jerk, oh my God, something may go viral. What's going to happen to my company, entity, medical practice, whatever. But it's true in all instances where there's an allegation of some wrongful conduct. You really have to conduct a proper investigation. Gather all the facts before you respond or take some corrective measure. So if you hear about certain posts by an employee, confirm the existence of the post. And obviously, if you're in New York, you have that prohibition against, forcing the employee to share. But if someone's saying, hey, Mary Ann posted something, well, how do you know that? I'm saying what should be obvious, right? Or do you have a copy of it? Get the facts first before you speak to the employee. Again, don't overreact to public sentiment or even just workplace grapevine where certain, rumors just may take off and create a very different image than the one that's real. That said, you don't want to move too slow either. And again, this is true of every investigation. You want to move as quickly as practicable in a manner that allows you access to all of the facts. Because if you wait too long and you let things linger and fester and so on, morale's going to go down. It's going to take over, as a talking point in the workplace. There's going to be a perception that you as the employer, you don't take these things that seriously. Back to what we were saying about having a social media policy. Well, that's nice. You have a policy, but when someone violated the policy, you didn't do anything for X amount of time. And again, take into account the impact that can have, patients who might be offended by certain posts, so customers or people quitting because of the severity of what conduct is taking place on social media sites. So again, don't react too quickly. Certainly don't react until you have all the facts before you, but don't respond too slowly as well.
Good, everybody. Well, it's our pleasure to be here today and provide you with this program. If you have any questions, we'll stay on for a few more seconds to see if anybody has some questions. We always enjoy doing these programs. Hopefully you'll be able to join us in some of our upcoming webinars in the near future. And everybody, we wish you a very nice day. Have a good one.
Take care, everybody.
Bye-bye.
Bye-bye.
Let's see if I can shut this off.
There you go.
Okay.
Voila.
No, we're still on.